Hello, hello. Malcolm Gladwell here. On this season of Revisionist History, we're going where no podcast has ever gone before. In combination with my 3-year-old, we defend the show that everyone else hates. I'm talking, of course, about Paw Patrol.
There's some things that really piss me off when it comes to Paw Patrol.
It's pretty simple. It sucks.
My son watches Paw Patrol. I hate it.
Everyone hates it, except for me. Plus, we investigate everything from why American sirens are so unbearably loud, to the impact of face blindness on social connection, to the secret behind Thomas's English muffins, perfect nooks and crannies. And also, we go after Joe Rogan. Are you ready, Joe? I'm coming for you. You won't want to miss it. Listen to Revisionist History on the iHeartRadio app, Apple Podcasts, or wherever you get your podcasts.
Tests like the SAT or the LSAT or many other standardized tests, they in fact do predict future outcomes. Not perfectly and not perfectly well for every individual applicant, but they are useful. So, that's kind of the bind we're in, is that we have these tests that produce disparate outcomes, but they also are useful in other ways, which is why I think over time, universities that discontinued their testing requirements during COVID, they're going to bring them back, as many already have started to.
This is Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan. Please subscribe or follow this feed on your favorite podcast app. That way, you'll have access to all our new episodes as soon as they're available. One of the things that has happened over the last couple of months, and we're now about 6 months into the Trump administration, is a slew of executive orders, many of them executive orders that repudiate or reverse course on things that have been going on for decades or even centuries. And there I'm thinking a little bit of, among other things, the executive order on birthright citizenship. But one of the areas of law where there has been the largest number of executive orders over a long period of time in civil rights is on how do we determine whether there's been discrimination or not, and what should we do about it. And so today I'm joined by my colleague, Rick Banks, who is the Jackson Eli Reynolds Professor of Law here at Stanford Law School, a professor by courtesy at the Stanford Graduate School of Education, and the founder and faculty director of the Stanford Center for Racial Justice, which aims really to confront and counter the polarization in American society that has infected issues involving race. And where Rick has been, I think, for a long time, one of those people who's a little bit counterintuitive in his thinking on some of these issues, and therefore really forces us all, I think, to think more about these things than we might otherwise have done. And that goes back even to the first of your work when you first entered the academy. And I think it's been kind of a through line of your work ever since. So today what Rick and I are going to discuss is an executive order that the president issued called Restoring Equality of Opportunity and Meritocracy, which rejects a legal theory known as disparate impact that for more than half a century has been a key piece of anti-discrimination law in the United States. So welcome to the podcast, Rick.
Thank you, Pam. It's a pleasure to be with you, and you are so kind. Whenever I'm feeling bad, I will go to you for some put-ups.
Oh, well, I am your biggest fan. Well, maybe not your biggest fan because you have so many, but a large fan. I'm a very large fan.
Oh, well, thank you.
So disparate impact theory as a way of thinking about anti-discrimination law traces back to a case called Griggs against Duke Power that was decided by the Supreme Court in an opinion by conservative Chief Justice Warren Burger in 1971. It was actually a case litigated by my old mentor and boss at the NAACP Legal Defense Fund, Julius Chambers. But Rick, can you tell us a little bit about the case and what the Supreme Court did there?
Thank you. I think we need to try to understand this doctrine and its history, because so much of the Trump administration, so many of the Trump administration's executive orders, reject things wholesale that in fact should not be rejected wholesale and that have some virtues. At the same time, that's not to say that there are no vices involved in some of these doctrines. And that's the case with disparate impact. In the Griggs v. Duke Power Company case from 1971, the Supreme Court issued a landmark ruling that centered on this question of whether the plaintiffs, what the plaintiffs have to show in order to make out a claim of discrimination. The defendant was a North Carolina Duke Power Company, which prior to the passage of the law, the 1964 Civil Rights Act, had openly discriminated against African-American employees. In short, the policy of the company was that white employees were eligible for the good jobs and Black employees were not. In short, that was the policy. When the law passed, at that time, the company had a policy in place where it would then assign people to jobs based on intelligence tests. And the people who scored high could get the good jobs, and the people who didn't were consigned to the bad jobs. As it turned out, perhaps unsurprisingly, given the state of education for African Americans in North Carolina in the 1950s and on into the 60s, the African American applicants did not score well on these tests. So they filed a lawsuit. The Supreme Court held in that lawsuit that the requirements that the company had implemented, which was the IQ test, and there's also a diploma requirement that the company implemented, that those criteria could be challenged on the basis of the outcomes that they produced. So there didn't have to be a showing that the company had intentionally discriminated or enacted the policies precisely because they wanted to limit opportunities for Black employees. Merely the evidence of disparate outcomes was enough at the first step to allow the plaintiffs to get into court.
Yeah. So, I mean, one of the things that's interesting is, in the abstract, saying, would a company like people to have high school diplomas before they work for them doesn't seem invidious in any way. But of course, for years and years, the company had hired janitors who didn't have high school diplomas, had hired secretaries who didn't have high school diplomas and the like. And so, one point that you make in a really great essay that you've written that we're going to make available to our readers on Stanford's website is, you might think that disparate impact is a way of smoking out actual intentional discrimination. That is, you put in place something that looks like a neutral rule, but in fact, it's designed to make it harder for members of minority groups or for women or someone else to get the job or get the benefit. And I think here, having a high school diploma requirement, if you know that large numbers of Black applicants aren't going to have one and you adopt it, you might be doing it for just that reason. I mean, in that sense, it's a little bit like the old grandfather clause case, right? Which said you can vote if your grandfather could vote as of 1866 and doesn't say anything about race, but we all know what that's about.
Yeah, and this is one of the ironies, frankly, of the Trump executive order, because the executive order it rejects disparate impact, and it's written as though the only purpose of disparate impact is to try to mandate equal outcomes across groups. The executive order starts and ends with that assumption that that's the only purpose. But of course, there's another purpose, which in fact is probably the central purpose, at least historically, that disparate impact was used to try to smoke out or redress covert forms of discrimination where we don't have obvious evidence of intent. And when you think about it, that sort of discrimination, once the Civil Rights Act is passed in 1954, would probably become the dominant form of discrimination because institutions know they can't openly discriminate, so they might try to do so covertly.
Yeah, you meant 1964, I think.
1964, I hope I said that.
No, you said 54. But...
Oh, I'm sorry. No, not 1964. 1954 was Brown. 1964. But the irony,
years with fours in them sometimes have good stuff.
Yes, but the irony of the Trump order is that, the Trump administration and its attacks on higher education and other institutions has actually resorted to a sort of disparate impact or quasi-disparate impact approach. Whenever the administration says, for example, we think that people are discriminated against based on their ideology, or conservatives are being banished from academia, and so we want the data. Whenever they start to ask for the data and they want to look at the outcomes, they're actually undertaking a disparate impact sort of analysis.
Yeah, it's a kind of Dr. Fell, disparate impact for me, but not for thee theory.
Well, I don't know if it's unclear to what extent the administration officials realize this is what they're doing.
Yeah. So I mean, there's a whole lot of disparate impact where really it's a way of saying we're pretty sure that you wouldn't have this impact unintentionally. And so the fact that you now have this impact suggests that you actually desire to have it.
Right. And the one other piece of that, of course, is that in order to make out a disparate impact claim, it has to also be the case that the employer doesn't have an important, legitimate, actual reason that they have the practice in place that's challenged. In other words, if the employer could show that the reason we have this particular testing requirement, say in Griggs, is that the test has been shown to actually predict performance on the job, then the disparate impact claim will fail, right? Because then you might intuit that the employer is using the criterion because it's related to job success rather than because it eliminates people from the disfavored group.
Yeah, I mean, that's what's sometimes referred to as the business necessity defense.
Exactly.
Is, yes, I understand that if we require that you have a PhD in physics to work in our physics department, there are going to be vastly more men being hired than women because the vast percentage of people who get physics degrees are male. Yes, there would be a disparate impact, but it wouldn't be unlawful.
And that's one of the ways in which the doctrine is sort of the limitations that make it unlikely that the doctrine can be used to pursue equal group outcomes no matter what, right? Because if the employers or the institution if they have a legitimate reason for using the criterion, then the disparate impact, it might be unfortunate, but it's not illegal.
Yeah, and the other thing that I found like super annoying about the executive order is the way that the executive order puts it is they say that disparate impact theory holds that a near insurmountable presumption of unlawful discrimination exists where there are any differences in outcomes in certain circumstances, even if there's no policy, and even if everyone has an equal opportunity to succeed. And of course, it's not a near insurmountable presumption. And it doesn't even come into play where there are any differences. I mean, if you're talking about employment cases, you have to show a pretty significant disparate impact before the employer is even required to tell you why it's using the
right. Yeah, and that's frankly why we should have this conversation, because there are aspects of the order itself which, to put it simply, are misstatements of the law as it currently exists, right? And but people who are out in the world, they don't understand that these are misstatements of the law, right? And so disparate impact can easily be vilified as this club that some plaintiffs are using to enforce equal outcomes no matter what. But that's actually not, in fact, the way it has worked in practice, and there's no reason to think it will work that way.
Yeah, and to go back to Griggs itself, this idea of kind of a random intelligence test as a criterion for a huge range of jobs. Mm-hmm. A lot of these tests that were given, not only did they have a disparate impact, they actually didn't measure intelligence, and they were measuring some random kind of general idea as opposed to whether people actually had the knowledge to do the particular job they were applying for.
Right. And one of the telling details in the case, of course, perhaps, is that before the intelligence test requirement was implemented, there were lots of white employees who were placed into jobs for which they would not have qualified if they had to take the intelligence test. But nonetheless, they were in the jobs, they were performing the jobs well, yet the employer asserted that the intelligence test was used to screen based on ability, but there was no evidence even that the test measured the abilities which were required for the job, right?
Yeah, so, I mean, there's a whole industry, of course, it's part of industrial organization scholarship about what kind of test you should give to figure out whether somebody can do a job. I mean, a lot of times You want a test that tests for the things that the particular job requires, rather than just some general test of, are you a good test taker or not?
Right. Yeah, no, that's exactly right. So, and this is let me emphasize though that we were talking about the equal outcomes point, that and this is in defense of the executive order, at least, or in trying to understand it, is that there actually are people out there who are advocating the thing that the executive order seeks to attack. So the executive order is attacking this view that disparate impact is nothing more than a tool of social engineering to promote equal outcomes no matter what. Now, that's not the way courts have interpreted and applied the doctrine in actual cases. So that's not an accurate description of the law. But there actually are people out there in the world, commentators and critics, maybe even institutional officials, who do think that all disparate outcomes are categorically impermissible, and that anytime you see a disparate outcome, you should strive to change things to avoid the outcome. So in that sense, there is at least a perception of a problem that the executive order is responding to.
Yeah, I mean, it's interesting because the executive order seems to be, in that sense, going after both the law, which it misstates dramatically, and then going after certain critics that are probably as kind of far to the left in that sense, I think is what you're saying. Is administration is to the right.
Exactly. And in other words, and this might be true about many executive orders, that these are kind of culture war, places where the culture war is fought. Right. Yeah. And is couched and framed in terms of legal doctrine. But in fact, the executive order, to say the least, doesn't accurately track the doctrine. It doesn't track judicial decision making. It doesn't do that. But what it does do is it describes the other side in this cultural battle. Right. And the Trump administration wants to show that it's against those who are pushing for equity or equal outcomes or anti-racism, whatever the term is. It wants to attack that group. And it does, in the process of doing so, though, it clearly misstates the law. And I think what's most unfortunate here is that, disparate impact, if we really got rid of it, that would sacrifice meritocracy, which is what the Trump administration says it wants.
Yeah, and that's one of the, so the first part of your essay kind of talks about, well, disparate impact is a tool for smoking out actual purposeful discrimination. And then you shift gears to point to the other, I think, really big thing that disparate impact theory does, which is it forces us to take a second look when we see a really big disparate impact on the basis of race or sex or religion or, age in the Age Discrimination Employment Statute, disability in the, Americans with Disabilities Act, forces us to kind of look again and ask ourselves, is this test or is this criterion actually measuring merit? Or is there a way that we can get to finding the best employees for this job or the best students for this college or whatever, that doesn't exclude people disproportionately who are members of minority groups or women or members of a particular religious group or the like? And so, for example, I kind of think here, we've been talking about paper and pencil tests up to now, but I think here a little bit about some of the tests that used to be used to pick police officers or firefighters. So one of the things for police officers, a number of departments had a kind of minimum height and weight requirement for police officers. Like you had to be at least 5'10", let's say, to be a police officer. And these criteria disproportionately screened out women. Some of the strength tests that were used for firefighters disproportionately screened out women. And they weren't adopted for those purposes. I mean, they were adopted because first order intuition is bigger and stronger is better than smaller and less strong. But then it turns out that there are many ways to be a good police officer, and not all of them require being large enough to intimidate civilian population. Being able to relate to and diffuse tension can be an important one. Having the ability to listen can be an important one. the like. And so departments were kind of forced by disparate impact theory to rethink how they put these criteria in place. And when they rethought them, they came up with ways of making police departments and fire departments that were just as effective, but in which there were many more women, many more men from ethnic groups that tend to be shorter and lighter than the average man and the like. And so that was kind of the second piece, I think, of what you were talking about. And I wonder if we could kind of move into that discussion of, the Trump administration says, on the one hand, you have disparate impact. On the other hand, you have meritocracy. And you're really saying, no, those two things are not inherently in tension with one another.
Yeah, I would actually even now, this is a really important point, and I would even go beyond what you just said. You said that they could change the criteria for employment, which results in a broader mix of employees, and the department would be just as good. It may even be that would have made the departments better, in fact.
No, I think it does make them better. But along the measures that they cared about, those measures didn't go down.
Yes, and this is a problem, especially in public employment, right? Where a lot of the hiring criteria were just based on traditions, or, as you alluded to, sort of stereotypical notions of, like, what does a good cop look like? What kind of person is this? And you might have imagined what a good cop looks like in 1930 or 1950, very different from what you would then imagine in 1970 or 1980 or 2020, what a good cop should be and what they need to do. So norms have shifted, yet the criteria, for all sorts of reasons, you might imagine they wouldn't shift as much. So what this means in terms of how we should understand disparate impact is that rather than being a tool to promote equal outcomes no matter what, right, disparate impact might instead be better understood as a doctrine that nudges employers toward best practices that embody a norm of meritocracy, that help them to hire the best employees when, for a variety of reasons, they might not do so on their own. And that's a good thing. And this is also a bigger point about the 1964 Civil Rights Act and the whole edifice of anti-discrimination law, because, many critics and perhaps the Trump administration might impugn that law as also taking away employers' choices and promoting equal outcomes and doing things that are un-American. But the reality is that the 1964 Civil Rights Act was probably a pro-meritocracy development, because it opened up opportunities for people from all backgrounds, and it nudged employers toward doing things which are good things and which we now take for granted. Things like posting jobs openly and, selecting from a broad pool of applicants. Practices weren't nearly as consistent in the world prior to the 1964 Civil Rights Act.
Yeah, I mean, one of the first cases that I worked on at LDF was a case that involved a very lucrative blue-collar job it was a union job. And the union's position was you could only become a member of the union essentially if you were the son of a member of the union, right? And, that obviously had the effect of reducing the ability of people from other racial groups to get that job.
Yeah, this is reminding me of the riverboat case.
Oh, yeah, my favorite, Patch against riverboat pilots. Yeah,
this was the case where you could only become a captain of the riverboat if you had a referral or
you
training.
had to do an apprenticeship.
Apprenticeships,
they only gave them to their sons and their nephews and stuff. And Justice Black, as you may remember, writes this unbelievable opinion that's like sort of Mark Twain and the lore of the river, and of course it's just sheer nepotism.
Right. And that's how things work. And that, frankly, just to make the point plain, that nepotistic system is anti-meritocratic, right?
Yes.
That's not a selection on the basis of who's going to be the best person for this job. That's a selection based on, this is my son or my nephew, and I want to pass the job on to them. And that's the way lots of jobs have worked over time. Yeah. And disparate impact is one of the many legal tools that have helped to break up that system.
Yeah. So, you have a book coming out this year called The Big Sort, which is about colleges and college admissions and the like, among other things. And, we have this question of when colleges admit students, Is that a meritocratic system? And what would it mean to say it is or it isn't?
Yeah. And this is another, this could be this will be many separate conversations, because this is one of the issues that society is struggling with and higher education institutions are struggling with. On the one hand, let me just to sort out the issues. Meritocracy in principle is a good thing. Sometimes that gets lost in our culture war. The idea of hiring the best people for the job, the idea of recognizing talent and hard work and having that determine one's outcome in life rather than pedigree or lineage, that's a good idea, right? And that's part of what the modern world is and should be about. So meritocracy as an ideal is a good ideal. But it's also the case that doesn't mean every embodiment or instantiation of meritocracy is what we should embrace. We also need to think about what the effects of the system are in a broad sense, both for individual students, institutions, and also for society. And one of the things I do in the book is kind of sort out these issues in some detail. So I'm very excited about that.
Yeah, it's a kind of complicated question when we think about, merit among 17-year-olds and letting them in, for example, to a highly selective university. Is it we should let in the people who are the smartest? Is it we should let in the people who we think will be the best leaders going forward? Should we be thinking about the extent to which letting them into our school rather than letting them go someplace else will make the biggest change?
Yep.
If you think about merit as a form of desert or deservingness, should it be the people who've overcome the most hurdles? There's a real question, I think, at a place like Stanford. Should it be somebody who runs the 40-yard dash faster than other people,
yes.
Right?
Yes.
So there are many different forms of merit. And, to go back to Koch against Riverboat Pilots, not clear that your lineage is a form of merit, and yet huge numbers of universities, including a number of public universities, give preference to children of the faculty, children of alums and the like. How should we be thinking about this when we think about disparate impact?
Well, this is a big issue. This is, again, this could be many conversations. Let me...
and we'll have you back when you
let me make the big point, though, that actually just having this conversation is about universities and the role of universities in society is both timely and really important. I don't think it's an overstatement to say that the health of our society in the future will depend on the health of its universities, in particular the research universities. We have educational functions that are important. We also have research and knowledge expansion functions that are really central to how our democratic experiment is going to play out long term. So it's a really important issue. And too often in public debate, the issues are just addressed in a crude, black or white sort of manner. And the nuances completely get lost. And what we need is a discussion that has more nuance where maybe we recognize it. With meritocracy, for example, it has important virtues, but it also has vices. And the principle should be applied in many settings, but there should also be limits to the principle. You mentioned the very contentious issue of legacy preferences and also preferences for other groups, for athletes, for faculty, students, even though that hits pretty close to home here. But those are all instances when merit properly defined in terms of the goals of the university is not being furthered, frankly. Right. And the rationale for those sorts of practices, it really has nothing to do with merit. It has to do with institutional goals that are non-meritocratic. And a core issue here with legacy admissions is that most private universities, and certainly most of the major ones, most of them have legacy admissions because admissions is very much intertwined with philanthropy. And the thing that makes American universities unique worldwide is the extent to which we have developed philanthropic practice, which has generated extraordinary riches for some universities. And those riches would not have come about many would contend, were it not for preferences in the admissions process that prompt potential donors to give large sums of money. And I think that's a hard issue to sort out, frankly, harder than many people might, right? In California right now, we have a law that's sort of an anti-legacy preferences law that's been passed. And I'm not sure what Stanford will or should do with respect to that law.
Well, in your essay, you point out that there is a disparate impact to a lot of the standardized tests that universities use in their admissions process. On the other hand, eliminating those tests might also have a huge disparate impact because
Yes.
remember a bunch of
Yes.
studies that have been done that show actually that kind of the so-called holistic admissions process often has more of a disparate impact than the tests do because
Yes.
it's so tied to familial wealth. That,
Yes. Yeah.
if you've got two kids who both, let's say, have 1,300 on the SATs, and one of them also has a foundation that he created that, managed to give away, 400 bed nets to malaria victims in some country, and the other kid worked in McDonald's over the summer.
Yeah.
One of them is going to look much more kind of interesting in that sense. But of course, the reason one kid was able to do that is his parents had the money and the connections and the kind of human capital to help him do that. And the other one is doing this because they need to make money to, support their family.
Yeah. No, this is a point that's not made enough, right? There are lots of critics out there of testing. And the assumption that many people have is that if we could just get rid of the admissions test and not make that so central to the process, things would be more fair. But the reality is that if you don't rely on the admissions test, you're going to rely on something else. And the other thing you'll rely on, as you note, might be more skewed in terms of race or class outcomes in the test result itself. So that's one big point that needs to be part of the debate. But the other big point that needs to be part of the debate, which is often not defended or recognized, is that test scores, in fact, are predictive. They actually are. I don't know about your experience, but when I arrived in law school years ago, having taken the LSAT, I thought that the sorts of things we were doing in law school, they were similar to the sorts of things that the LSAT required one to do.
Yeah, I'm so old, Rick. I don't remember what was on the LSAT. I remember my score and nothing else.
There wasn't perfect overlap. And tests are not perfectly predictive. But, tests like the SAT, which in fact was initially, was designed from intelligence tests, right? And there's a horrible history there, which is racist and, very much focuses on looking for inborn differences between people. But that history doesn't negate the fact that tests like the SAT or the LSAT or many other standardized tests, they in fact do predict future outcomes. Not perfectly and not perfectly well for every individual applicant, but they are useful. So, that's kind of the bind we're in, is that we have these tests that produce disparate outcomes, but they also are useful in other ways, which is why I think over time, universities that discontinued their testing requirements during COVID, they're going to bring them back, as many already have started to.
Yeah, and we'll have more opportunities to talk about this later. But there's so much going on with disparate impact and anti-discrimination law. And it's great to have the chance to talk to you, Rick, because you are somebody who is able to see the arguments on both sides, see what their strengths are, and see what their weaknesses are. So I want to thank you for joining me today. This is Stanford Legal. If you're enjoying the show, please tell a friend and leave us a rating or review on your favorite podcast app. Your feedback improves the show and helps new listeners to discover us. I'm Pam Karlan. See you next time.